Welcome to Landmark Chambers webinar, the review of judicial review, reflections on the Faulks review. We are delighted to see so many of you joining this session today and hope that you will find the presentations and discussions to be helpful and informative. My name is Richard Drabble QC. I will chair the session today, joined by my colleagues David Locke QC, Samantha Broadfoot QC, Tim Buley QC, Kate Olley, Justin Bates and Alex Goodman, to whom I will formally introduce in a moment. To begin with, a few housekeeping points to note. Your microphones are automatically muted, so you will not need to adjust your local settings. We very much welcome questions throughout the session. Please submit them via text in the Q&A section, which may be found at the top or bottom of your screen. We will endeavour to answer as many questions as possible at the end of the presentations. This webinar will be recorded. You will receive a link to the presentation and the recording shortly after the event concludes. And if your connection is lost at any point during the webinar, we invite you to rejoin the meeting by clicking on the original link once more. I have some short introductory remarks on slides about the basic structure of the independent review of administrative law, IRL, as we will come to know it, and come to know and love it, no doubt, over time. Just to run through the slides, key facts about the review are that the IRL has issued a call for evidence, which runs from the 7th of September this month, a few days ago, until the 19th of October 2020. And there's a request that responses are sent to IRL by the 19th of October 2020. There's a straightforward statement that the review will submit recommendations to the Lord Chancellor and Michael Gove by the end of the year. And I've set out on the first slide the participants in the review. We will see as we go through this short introduction that Lord Faulks's general perspective on some of the issues raised in the review are fairly well documented. He's expressed various concerns and we know what they are. It's a bit more of a puzzle to know what the views of the remaining members of the panel are, and that's one of the things that will have to be worked out, and those of us who are going to be responding to the review will have to take into account. So let's go see what we can identify from the published material in terms of the likely focus of the review. Key issues identified in terms of reference and the call for evidence are first of all discernible from the title. Call for evidence, the title is, the call for evidence is, does judicial reviews strike the right balance between enabling citizens to challenge the lawfulness of government action and allowing the executive and local authorities to carry on the business of government. So that concept visible in the title of the balance between the ability of individuals to challenge government action and allowing the executive and local authorities to carry on the business of government is there from the very beginning. And it's quite apparent that a great deal of the concern of government that's led to the setting up of the review is a feeling that the judicial review does function as a burden on the business of government. The review identifies, or the call for evidence more precisely identifies from the terms of reference, the following specific areas for inquiry. Firstly, whether the amenability of judicial review of public law decisions, judicial review in the grounds of public law illegality, should be codified in statute. Tim Buley will be dealing with that, and we'll has some thoughts about how useful or otherwise an attempt to put judicial review on a statutory basis is likely to be. Secondly, whether the legal principle of non-justiciability requires clarification, and if so, the identity of subjects and/or areas where the issue of justiciability or non-justiciability could be considered by the government. Now, we've seen already that the timetable for the judicial review, for the review of judicial review is short. Roughly a 6-week period for the call for evidence to be met, and it's envisaged that a final report will go to the Lord Chancellor and Michael Gove by Christmas. That short timetable ties back into the wording of the second bullet point, because what's envisaged in the second bullet point is that the review will identify subjects or areas where the issue of justiciability or non-justiciability could be considered by government. That wording seems to be recognising that the review will not come to final answers on the question of whether there are areas which should be no-go areas where the issue of justiciability should be held by government not to be available. Rather, it's envisaged on that wording that the review will have a look at what requires further consideration. That may be not right, but that's certainly the way in which it's worded. The third issue is whether if a public law decision should be justiciable, on which grounds there should be justiciable, whether those grounds should depend on the nature and subject matter of the power, whether the remedies are available in respect of the various grounds. Going back to the basic theme of balance between the concerns of citizens and the burden on government, it seems to me that one of the major issues for the review is going to be remedies. I'll come back to that issue in the very short time I've got available in a moment. But there's basically likely to be some concentration upon whether the normal position that if there's a public law error in a decision, the decision is void, is actually the right answer. Lord Faulks is plainly determined to ask whether that automatic voidness should be the ordinary consequence of a finding of breach of whatever legal ground is laid out. And then the final bullet point is whether procedural reforms are necessary, and you'll see that goes into some detail on the burden of, looking at the burden of effect on disclosure in particular in relation to policy decisions, duty of candour, possible amendments to the law of standing, time limits for bringing claims, and the principles upon which relief is granted. So back again to relief, and rights of appeal, including rights of appeal related to the permission stage of JR. Now, it seems to me, and we've got a final slide dealing with this, it's possible to separate the review, the Faulks review, into two basic themes. First, a feeling that judicial review over the last 40 years has taken a wrong turning, become in principle too intrusive. And secondly, much more pragmatic set of concerns isolated in the last bullet point on this slide, concerning duty of candour, effect of the burden of disclosure, and that sort of pragmatic view about the impact on administrators. The footnote to the terms of reference records in a passage which both David Locke and I have set out, the fact that in the view of the author of the footnote, which presumably has a lot to do with the members of the panel, historically there was a distinction between the scope of a power, whether prerogative or statutory or insubordinate legislation, and the manner of the exercise within the permitted scope. Traditionally, this was subject control by the court, but the second was not. Over the course of the last 40 years at least, the distinction between scope and exercise has arguably been blurred by the courts, so that now the grounds for challenge go from lack of legality at one end, scope, to all of the conventional JR grounds of proportionality at the other, exercise. Effectively, therefore, any unlawful exercise of power is treated as a decision taken out of scope and therefore considered unlawful. And the basic question asked is this correct? And if so, is this the right approach? Now, David Locke has some basic points about whether that footnote accurately describes what the position was more than 40 years ago. I have another point, another 2 points actually. If we look at the footnote, it's not concerned simply with whether or not prerogative powers are reviewable. It's not the source of the power in the sense of it being prerogative rather than statutory. The subject matter, the target of the footnote is the exercise of all powers, whether prerogative or statutory or in subordinate legislation. And it's saying that judicial review may have made a wrong turning in looking at the legality of decisions made within scope, even in a statutory or subordinate legislation sense, because of the manner in which the power has been exercised. Secondly, the choice of the course of the last 40 years as the time frame within which the review, which is envisaged the review will look, the course of the last 40 years at least, the distinction has arguably been blurred, brings within the relevant time frame what I regard as the great flowering of judicial review in the early 1980s, decisions like GCHQ on the reviewability of the prerogative, the IRC case on standing, and so on. So the argument appears to be a possibility that judicial review took a wrong turning in those great seminal cases in the early 1980s. Now, if that is the review, what is proposed is a major law reform exercise. Now, for a short insight into what Lord Faulks thinks may be in frame in the review, there's a very readable article by Francis Gibb with an interview with him in the Times a few days ago. Unsurprisingly, that features the prorogation case, which Lord Faulks says in terms that he agrees with the divisional court that it was a matter of politics. But the scope of the concern is also shown, by example, for the mentioning of the Supreme Court case about tribunal fees in unison, and the disapplication of the Carl-Toner doctrine in the case concerning interment of Gerry Adams, holding the personal signature by the Home Secretary was required. So there does seem to be a very general concern about the intrusiveness of judicial review for a variety of reasons, which don't fit entirely into the footnote, actually. The structure of the call for evidence is that Section 1 states that IRL has created a questionnaire to be sent to government departments. I set out the opening words of the questionnaire there, asking government departments to provide evidence about whether or not they think JR is interfering with their functions. A to K of a list which follows that set out the classic grounds for review and ask whether those are causing problems, but also referring to standing and time limits, and ends up by asking the administrators, does the prospect of being judicially reviewed improve your ability to make decisions? If not, does it result in compromises, sorry about the typo, which reduce the effectiveness of decisions? And then the remainder of the review of the call for evidence deals with the desirability of codification and the more pragmatic aspects of the concerns about process and procedure, cost, standing and remedies, etc., down to details like have you experienced a settlement at the door of the court? Should there be more of a role for ADR, etc.? Importantly, the call for evidence, neither the call for evidence nor the terms of reference nor anything else set out any specific proposals for reform. If those are going to emerge, they will have to emerge later in the stage, in the process, and there's an obvious tension between the very short timetable and the radical nature of the issues raised by the footnote that I've referred to. Two different aspects to the review, which I've said, 40-year point, and a separate set of concerns about the burden on administrators arising from obligations of disclosure and the resources that have to be devoted to defending a challenge. So that's my short introduction. I now pass you on to Justin Bates, who will make some points about whether or not the issues raised by the review can actually be confined to straightforward judicial review issues. So Justin, over to you.
Thank you very much, Richard. Yes, I'm a slightly odd place to start this talk from, and I will keep myself relatively tight for time as a result, because what I want to talk about is things that aren't really central to the work of the review. It's more about knock-on implications, some of which are alluded to in the review documentation. And in particular, I want to talk about how you could see quite substantial and significant changes to my favourite area of law, and indeed the greatest area of law, housing law, if you start changing the nature of judicial review. And in particular, I want to flag up something that's in footnote F of the consultation document. So Richard's already taken you through the terms of reference, and there'll be others looking at this in more detail later. But you see in broad terms, it's talking about codification, justiciability, and then grounds. And then tucked away in footnote F at the end of the document, the authors note that if they were to change some of these things, it would have an impact not just on judicial review, but would modify substantive law in relation to other areas, in particular, my favourite area, tenants raising defences in private law housing possession proceedings. We've moved on quite a long way since Wandsworth and Winder, and Mr. Winder's contention that Wandsworth Council weren't quorers when they managed to set his rent increase in 1981. But public law protections as an aspect of social housing law are a good example of the wider problems that will emerge, or the wider tensions that emerge, if you play with public law in the narrow sense. So footnote F sort of suddenly got the alarm bells ringing in my mind, but in particular three questions about, well, how far is this review intended to go? Are we intended to worry about disputes of a public law nature between public authorities, which we see a lot of in housing law and in community care law? What about quasi-judicial review issues? Because since 1996, homelessness appeals, which were previously judicial review claims, have been dealt with as statutory appeals on judicial review grounds in the county court. And I strongly suspect if you were to count up all of the number of appeals that take place in the county court by way of county court judicial review, you'd see that they represent probably second only to immigration law in terms of pure numbers of cases. And then thirdly, the public law defences issue that's mentioned by the authors of the report. Of course, you'll all immediately have picked up, it's not limited to housing law, as important as housing law is. Winder is just another example of the broader principle that comes from Boddington about the ability of the citizen to raise public law points in their own defence when the power of the state is being deployed against them. Now, I'm not going to go into a full discussion about Boddington and your ability to raise public law defences to criminal law, because I don't do any of that. I only do housing law. But those are some of the implications of this review. I just wanted to touch on them briefly, each of those three in turn. Disputes between public authorities in housing law and in community care law are very, very common. And I've given just three examples there. Ordinary residence disputes, for example, in social care cases or in Children Act disputes, you frequently get situations where someone is physically in the area of one local authority, but in fact all of their ties and their base is in the area of another local authority. And so the dispute becomes between two local authorities about which one of the two authorities has the various responsibilities for this person, whether under the community care legislation or under the children legislation. It's not immediately apparent to me that the authors of the review appreciate that inter-public authority disputes are an aspect of judicial review. because when you look at the questions that are posed, they seem to only envisage citizen against state, whereas, as we say, clashes between organs of the state are an important part of public law. In particular, if I look at my examples 2 and 3, in my field of housing law, there are 2 situations at least where local authority versus local authority is the only remedy if there's a dispute. So imagine, if you will, that you are a homeless person who's applied to a local authority for assistance. The first authority you apply to has to process your application and decide whether you are eligible for assistance, whether you're homeless, whether you're in priority need, etc. And at the end of that, once they've decided what substantive duty is owed, there's a discretionary power to refer you to a different local authority if it transpires that you have a local connection, as it's called in the trade, with a different local authority. And the second authority is bound by the conclusions of the first. So if the second authority disagrees, for example, they say you're not eligible, you have no right to be in the country, you shouldn't be getting homelessness support, the second authority has to judicially review the first authority to try and get that decision overturned. Now, those cases are rare, but there are 2 in the law reports there that I can come across. And they are the only real way that local authorities can protect themselves if they consider another authority has made an erroneous decision. Similarly, cases where the local authority, in colloquial terms, has to judicially review itself. Now, this will come about more often than you might think. If a local authority allocates social housing other than in accordance with its allocations policy, then it would have to judicially review itself in order to have the allocation quashed. That's a Court of Appeal case from about a decade ago called Birmingham and Kazim. In practice, what happens is the leader of the local authority judicially reviews his local authority. But in the absence of statutory powers to recall bad decisions, that's how local authorities have to step in and try and get themselves out of difficulties. Now, again, if you change judicial review, you risk changing some of the way that works. And I'm not necessarily sure that's what the authors of the report authors of the terms of reference have in mind. What about quasi-judicial review claims? Now, again, I'm going to use housing because that's my area, but you all know of other areas where there are appeals on a point of law. And the phrase appeal on a point of law generally means an appeal on effectively judicial review grounds. You know, the case there from House of Lords in the homelessness context, the Runa Begum case. So you're a homeless person and you want to challenge a decision of a local authority that they don't owe you a particular duty. You appeal to the county court on a point of law and you can raise all of your judicial review points. Why is it intended, if it is, that that should change simply by sidewind if you end up changing the procedure on judicial review or changing the grounds of judicial review or restricting the grounds of judicial review? If it's not so intended, do we risk a situation where we have 2-tier judicial review? We have the judicial review as it applies in the High Court and judicial review as it applies to quasi-public law claims in the county court or other statutory appeals. Again, in my particular interest of housing law, there's a devolution issue there. For all our friends at GLD who are listening to this, there's a devolution issue because housing is a devolved issue. And whilst presently the Welsh Assembly, Welsh Government have adopted the same test as in England for homelessness appeals, there's nothing to require them to. They could take a much more liberal approach if they were to take the view that England introduced unreasonable restrictions on judicial review, and that in turn meant that appeals on points of law were being unreasonably restricted. And then finally, the point touched on by the authors of the terms of reference themselves, the ability of the tenant to raise public law defences. This has been much litigated since Wandsworth and Winder, and there's now quite a lot of learning on it in the social housing possession field. Most recently, the 7-person Supreme Court in Kay and Lambeth, about the extent to which and on what bases you can raise a public law defence to a possession claim brought by a social landlord. The availability of such defences has become an integral part of the wider regulatory regime of social housing. In particular, again, for our friends at GLD who are on this, when the government creates a new mandatory ground for possession, as they've done with quite a lot of social housing recently, generally in relation to, most recent example, for example, have a look at section 107D, Housing Act 1985, all about flexible tenancies. But when they create a new mandatory ground, the way they tend to justify it in Parliament is by saying, although we say it's a mandatory ground on the face of the Act, we accept that actually it's subject to traditional judicial review defences in the wider sense. So the balance that's been struck in various statutory schemes about the rights of tenants to raise these defences is partly predicated on the existing relatively generous approach to what can be taken as a defence. It goes beyond just local authority tenants, of course. It's anyone who is the tenant of a public authority. Now, most of you, I'm sure, will know and will have seen the various cases about whether housing associations count as public authorities for these purposes. The Weaver case being the probably the go-to case on this still. But it's not only housing associations it applies to. A whole range of non-traditional but quasi-public sector landlords are subject to public law defences to their possession claims. The most recent to join that list by virtue of Court of Appeal decision is the Canal and River Trust. So people who have their riverboats sailing around the canals of Camden are entitled to resist possession proceedings brought by the Canal and River Trust on public law grounds. And if you don't have any security of tenure, and a person on a canal boat is unlikely to have any security of tenure, then the availability of the public law defence is the only way to prevent what would otherwise be an unjust or even unlawful removal of your home and removal of your ability to live in your home. Now, as I say, I appreciate that very few of these things are core public law, and I appreciate they're not perhaps what the review has in mind. In particular, the fact there's no questionnaire to local authorities or other public bodies gives you the indication that the primary concern here is about protecting the government interest, the central government interest. But because of the way that public authorities who aren't central government use public law, both to protect themselves and to help regulate the services and rights of citizens, services they provide citizens and the rights of those citizens. If you tinker with judicial review in the broad sense, you inevitably risk a knock-on consequence that you may not necessarily have intended. And my concern, finishing up here before handing over to a colleague, my concern is that by a sidewind, reforms that are proposed to protect central government and to improve the position of central government as against the citizen end up having a harmful effect on local government, particularly as against other branches of local government, or citizens who interact with local government. And that, to my mind, that is one of the big, potentially unintended consequences of this particular review. Now, time is tight and we're all strictly limited to 10 minutes. So I've managed to use up 8 of mine, which means Tim can now have 12 to talk about reflections on the review and should judicial review be codified.
Thank you, Justin. I'll try not to be. I'll try not to use up the full 10 minutes. I think we're running a little behind. I'm going to be talking about really the first of the questions in the terms of reference. I'm just going to, before I come to that, I'm just going to say, make an apology, which is that I think there's inevitably going to be some overlap both on what I say compared with what you've already heard from Richard and probably with what follows. I don't think that's our fault. I think that's inevitable given the kind of way the terms of reference and the questions are framed. There's a lack of coherence in all of this, I think. But I'll try to avoid repeating things that have been said or more cautiously that may be said by others. Okay, so the first question in the terms of reference then, whether the amenability of public law decisions to judicial review by the courts and the grounds of public law should be codified in statute. And that has slightly morphed in the call for evidence. So as I understand it, the terms of reference are drafted not by the panel, but they're what's given to the panel, whereas the call for evidence, it may be that some members of the panel had some input. The call for evidence presumably is within the control of the panel. And that's morphed, and the heading, I should have put it in the slide, the heading to this part of the call for evidence is codification and clarity. And it's question 3, which is really relevant. Is there a case for statutory intervention in the judicial review process? If so, would statute add, and I've underlined, certainty and clarity to judicial reviews? To what other ends could statute be used? And it may overlap, although it's really more David Locke's territory, with the next question about, which I think is a question about justiciability, and what decisions should be subject to judicial review. Now note that there's a slight, or arguably a slight, change of emphasis, which in some ways I find quite encouraging. In the terms of reference, the question is, should we codify the grounds? But it doesn't say for what purpose. Whereas in the call for evidence, the implication is codification and clarity. Would it add certainty and clarity? It looks like it's codifying for the purposes of clarification, not for the purposes of fundamental reform. Whether that's really right, I'll come back to in a minute. So what would codification look like? I think that's a really difficult question to answer, or if you, the more that you think about it, the more problematic it becomes, and the more one starts to question the purpose of all of this. You will all, I'm sure, or most of you will be familiar with the very famous statement of the law on judicial review by Lord Diplock in the CCSU case, where he explained that there are 3 grounds for judicial review. The first he would call illegality, the second irrationality, and third was procedural impropriety. He then goes on to refer to proportionality, which has been in the wings for as long as I've been practicing public law, but still doesn't seem to be a ground for judicial review, at least in a freestanding way. So there you go, there's the 3 grounds for judicial review. You could obviously envisage section 1 of the JR Act 2021, which sets out those 3 heads of JR. Section 1.1, the grounds for judicial review are 1, illegality, 2, irrationality, and so on. But I strongly doubt that that would provide any greater clarity on what on how judicial review is supposed to work. Indeed, if I think back to myself as a law student, I remember reading Lord Diplock's statement, and no doubt conscientiously noting it down so that I could reproduce it for the purpose of an exam result, but not really understanding in any meaningful sense what he was going on about. I think after about 18 years of practicing almost exclusively in public law, I've got a rough idea, but I still don't find that statement of the grounds terribly illuminating. In particular, if I think to the cases that I've been involved in, because when I think about what happens in practice when I bring claims for judicial review or defend them or whatever role I may have, it's pretty rare and specialist that one is arguing about certainly irrationality. We all know the difficulties of bringing an irrationality challenge. I'm always pleased if I'm on the defendant's side and I see a irrationality challenge. And the relative rareness, although it's an important ground, of course, of procedural impropriety type challenges. Most cases, in reality, come under the heading of illegality. And of course, what that means in a particular context is as various as the statutory schemes and the statutory context to which judicial review can relate. Because in most cases that I end up being involved in, I suspect this is true for most practitioners, what you end up focusing is not the grounds of judicial review as they're taught to us in law school, but what does this particular statute mean, or how does this particular statutory scheme work? And so that's why, whilst it's an important statement, of course, by Lord Diplock in the CCSU case, that's why just saying that the grounds for judicial review are illegality, irrationality, and procedural impropriety is so unilluminating to the law student and to the novice in judicial review. Presumably the expert doesn't need the codification. And it also points up, I think, a fundamental further problem and potentially incoherence about all of this idea of codification. First of all, how on earth would you codify beyond that bull statement of the 3 grounds for judicial review? But secondly, what exactly are we dealing with here? Because the theory behind judicial review, or the most orthodox theory behind judicial review at any rate, is that judicial review is just about the grounds for judicial review arise from the presumed intention of Parliament, which is to be derived on each and every occasion, though one doesn't need to go back through the exercise, of understanding what Parliament intended by this particular statute. If Parliament says that the powers of a particular body are X, Y, and Z, then it's presumed that the courts are to interpret what the limits of those powers are how they should be exercised, that the public body must properly understand the legal powers that it has and the purposes for which it's exercising them, and so on. Any attempt to codify that, unless you set out every possible statute, becomes completely impossible, an impossible exercise. So certainly if that's what's meant by codification, it's difficult to see how it serves any meaningful purpose. Can one envisage then anything which is, and sorry, just a final point, reflecting back on Justin's talk, there's another point about that, which is that, of course, judicial review is just a procedure. This is why there's a tension between reforms to the grounds for judicial review and the subjects that Justin was talking about. And well, hold on, what are the implications of this for other forms of procedure? That's why ultimately all that judicial review is a mechanism for enforcing the law, not the public law, but the law as laid down by Parliament in particular cases. And so it's very difficult to work if you can't rely on these points. If something, are we changing the nature, what it is to be illegal, or are we just changing the grounds that you can rely on in this particular procedure? So can we envisage then a slightly expanded list that doesn't do the exercise of trying to envisage every possible argument that could be made in a claim for judicial review? Well, that's, I mean, the list can be as long or as short as you like, but just to illustrate what it might look like, as it happens, question 1 of the call for evidence, which Richard has cited, this is, as already referred to, this is a question which asks public authorities what the implications for them of judicial review are, and it says, can you please give evidence of the implications of judicial review along various grounds, and then it lists out a number of the grounds. So it says judicial review for mistake of law, judicial review for mistake of fact, procedural impropriety, legitimate expectations, Wensbury, irrelevant considerations. And then it says, and this I think is very telling, any other ground for judicial review. In other words, there's the beginnings of what might look like a codification of the grounds beyond the three from the CCSU case. But of course it runs into the sand because, as we all know, the potential grounds for judicial review are overlapping, they're very difficult to define, they depend upon the particular context, and so on. And that suggests to me that any attempt to provide a sort of middle ground list is going to run into the sand in the same way. I suggest that in reality, at least so far as the purpose of all this is just clarification and not a more radical reform, it's impossible to think of a modest or short or effective list which is going to serve the purpose of capturing all of the grounds for judicial review. Now that has certain dangers. Not only does it not really serve any purpose, what on earth have you clarified by even either the very short list or the slightly longer list I've got on this slide, or something that builds on this slide. But of course you have the danger that you then restrict the development of the law in the future in a way which may be what the government intends, but it seems a rather odd and abstract and quixotic thing to do, given that that's a development in the law that will happen over decades, not years. I've assumed so far that the purpose of all this is just that idea of clarification, which certainly seems to be, you would normally take from the idea of codification, which seems to be assumed by the panel's question. But there is some reason to think, there are reasons to think that the aims behind all of this are more wide-ranging, more sinister, depending on your perspective. Obviously there's a general political background which I'm not going to go into, but I'm sure you're all fairly familiar with. But even if you just focus on the consultation papers, the call for evidence and so forth, and the terms of reference, you can see that. Now, Richard Drabble has already set out the passage, and he's mentioned that David Locke is going to set out this passage, but not mentioned that I am going to do so as well. So I'm sorry I won't dwell on this passage too long, but this is the passage Richard's already mentioned, where the court talks about the case law in judicial review having taken a wrong turn 40 years ago. By my reckoning, the seminal case, in fact, in all of that, the case which, not exclusively, but by the most important case which brought to an end the distinction between, if you look at the first sentence there, the manner of the exercise of the power and the scope of the power. The seminal case is, of course, the Ennis Minute case. That's a 1969 case, so I think that's 51 years ago, not 40. And if we really are going back to re-examine that, means, as Richard has said, that we're looking at a very radical reform of judicial review indeed. Very difficult to see, and I appreciate this is partly about the justiciability issue, which David Locke is going to talk about in a minute, but in fact these issues are very difficult to distinguish. Very difficult to see how that sort of exercise is consistent with the idea of mere codification of the existing law. What's the other reason? Well, again, Richard's touched on it, so I'll just mention it briefly. The thrust of the questions, and I've set out some parts of them on an earlier slide, the thrust of the question in section 1 of the call for evidence is an invitation for public authorities to say why judicial review is problematic or vexing to them. It's reasonably predictable, I think, that at least some of those public authorities, I'm sure not all, but some of them will say, yes, it's jolly annoying, and they'll put in evidence, and it seems to be almost an invitation to them, to an open invitation to them to do this, to put in evidence to the effect that it is actually very vexing and causes them all sorts of problems, and therefore the judicial review is harmful. Note that there's no corresponding invitation to NGOs or individuals or companies who've brought claims for judicial review to explain why judicial review has been important or valuable to them. That may be coming, of course, such responses can be made, but there's not the explicit invitation to that. There's, I think, a fundamental ambiguity about the idea of what would improve decision making in the context of judicial review, where, after all, by definition, the question is the legality of the decision. And fundamentally, there's a real lack of clarity how this sort of question is designed to inform the other questions, including the one that I'm looking at, codification. But certainly that point and the point on the previous slide suggests that what's behind this is not mere codification in the sense of clarification, but a more wide-ranging reform. Now, as Richard has already pointed out, that's deeply problematic. This is a process that goes on over a period of a few weeks and over a relatively short space of time. Just very quickly, and last really thought from me before I very quickly wrap up, there is, in my view, a real issue if we are looking at radical reform, not only about the propriety of doing it or doing it so quickly, but a fundamental issue about the constitutionality of such reform. It goes back to the potential incoherence of a reform of grounds for judicial review that purports not to be changing the underlying or fundamental law. In the Anna's Minute case I've already referred to from 1969, the House of Lords struck down or nullified an ouster clause on the basis that it couldn't mean what it said in the sense of ousting judicial review, and that was followed only very recently in the Privacy International case, where the court not only reinstated the Anna's Minute approach, but also some members of the court question the ability of Parliament to limit the role of the High Court in judicial review. It's not quite the same issue. It's about ouster clauses rather than the grounds, but the same conceptual issues I think would arise in the context of any really radical reform, or as opposed to tinkering around the edges of the grounds for judicial review. So there it is. It's very unclear really what this is going to achieve. If it's just about clarification, very difficult to see purpose or the benefit of it. If it means something more radical, then it's a very odd way of going about it. Thanks very much. I think I'm handing over now to David Locke.
Thank you very much, Tim. Ladies and gentlemen, I'm been asked to look at the issue of the challenges to powers, and I come at this perhaps slightly unique in that I have across my career been a member of the executive when I was a junior minister, a member of the legislature, of course, as a backbench member of Parliament, and now a part-time member of the judiciary when I sit as a High Court judge. So I have the ability to experience this issue from all three perspectives, and therefore coming at this, it seems to me that the first question to ask is whether the fundamental approach taken by the review is actually correct. And this paragraph has been referred to by Richard and by Tim, and I make no bones about coming back to it, because it seems to me that is where the review starts. And essentially what it suggests is that judicial review, as a result of activist judges has taken a wrong course by expanding the scope of the power of the judges to intervene in what the executive are doing when they exercise powers. And what this paragraph says is traditionally the only question for the court was whether the power has been exercised within scope or not. In other words, whether the decision maker properly had the power that he or she was purporting to exercise, and has brought in a whole series of additional grounds under which, if there is the power, nonetheless, the decision maker has to be accountable for the way, for the exercise of that power on the grounds of proportionality at the far end of the spectrum. And the question raised is whether that movement away from pure scope towards assessment of the legality of the decision within scope, the exercise, is or is not a proper process that's happened over the last 40 years. And it seems to me that the first question to ask in addressing this is, what is this right? There are clearly established no-go areas for the courts, and I've put there Article 14 of the Bill of Rights, which is that the freedom of speech and debates in Parliament is protected. And there have been two recent decisions on the scope of Article 14. The Chater case, which was all about whether or not you could prosecute MPs for fiddling their expenses, or what they did in terms of their expenses was a proceeding in Parliament and therefore couldn't be questioned in the courts. And the courts decided, not unsurprisingly, the Supreme Court decided that what is or is not is a proceeding in Parliament is a decision for the courts, not a decision for Parliament. So Parliament can't define the area of its own jurisdiction and keep out the courts. And then, perhaps more controversially, there's the prorogation decision, which decided that prorogation of the House of Commons, House Lords, was not a proceeding in Parliament and therefore was outside Article 14 and therefore was subject to judicial review on the usual standard basis. The first case caused no political kickback at all. I think there was a general feeling that MPs who fiddle their expenses should be brought before the criminal courts. The second case, of course, caused enormous concern. But there is a very long established no-go area for the courts in terms of Article 14. However, the question as to whether the courts have added to their powers in the last 40 years, setting up a dichotomy between scope of powers, the vires, and the exercise of those powers is much more controversial. Essentially, that the distinction which is set up in the terms of reference between the scope of a power and the exercise actually doesn't seem to be consistent with the case law. The classic case is associated with Provincial Picture Houses and Wednesbury Corporation, and the facts of that case were, this is a 1948 case, were that the picture houses were complaining about the license terms set by a local authority, which said that nobody under the age of 15 was able to attend a screening of a film on a Sunday. And the Court of Appeal said that that was a power exercised by the local authority, and it was perfectly proper that they should use their discretion to set that type of condition. And but in doing so, they made it perfectly clear that the where the public body has the power, nonetheless, there are a range of grounds on which a challenge can be brought. Bad faith, dishonesty, unreasonableness, attention given to extraneous circumstances, and so on. And they referred, it's an interesting case, to a 1921 case, which is Short and Poole Corporation, where the example was given about a teacher in that case who was dismissed because, for example, they had red hair, and that was thought to be unreasonable. It's interesting, the facts of Short and Poole were that Poole Corporation had decided to dismiss all married women on the grounds that they ought to be standing by their husbands and not taking up the positions as teachers. And that was considered to be reasonable within the grounds, but dismissing men on the grounds of their colour of hair was not reasonable. What's important about this case is, though, it is not that the way that they worked. The fact is that back even in 1921, the way in which a power should be exercised, if it was exercised on alien or irrelevant grounds, led to the court quashing the decision. And therefore, the idea that this is somehow something new, this is something emerging, it's different, is simply wrong. There has always been the ability to challenge the exercise of a power. In terms of bylaws, and look at the test of unreasonableness in bylaws, one can go back to 1898 and Cruz and Johnson. And the improper purpose doctrine may have expanded as a result of Padfield and so on, but in fact it builds on very clear 19th century foundations. So what's really going on here? I don't think the argument that there's been a substantial shift in decision making by the government, by the courts, actually is correct. It seems to me that what the judicial review process is still asking, what decision was made, by whom, for what reason, for what purpose, and for what reasons. And what underlies this is actually a political question about whether the present level of scrutiny that's provided by the courts should be curtailed. There are some who think it should, there are some who think it shouldn't. But that's really what's going on here. It's not a case that the courts have expanded their area of interest into improper areas of the government. Doesn't seem to me to be consistent with the case law. But it is a question, a political decision in the end, not for the lawyers in a sense, as to how much scrutiny public bodies ought to be subject to when they take decisions. And is the present level of scrutiny, bearing in mind that in an era of where everything is on email and there's a data trail for everything, is the present level of scrutiny too high? That's a political decision, and that's for the government. And I think that's really what the heart of this review is all about in one way or another.
Good evening, everybody. I'm Sam Broadfoot, and my short take on the topic that I've been allocated is on the duty of candour and disclosure. So, as everyone knows, the normal rules of civil litigation and disclosure do not apply in judicial review. Practice direction to the CPR, Part 54, states that disclosure is not required unless the court orders otherwise. What this means is that Part 31, which sets out the rules applicable on standard disclosure in civil litigation, will not ordinarily apply on an application for judicial review. But instead, there's an obligation on the public body to comply with what is known as the duty of candour, a special duty which requires the parties to ensure that all relevant information and facts are fairly and fully put before the court. This gives rise to two questions. Timing, when does the disclosure obligation kick in? And two, scope, what is the extent of the disclosure obligation? And is there sensible scope for reform on these points? In order to think about these questions, it's useful to remember how the two concepts have developed over time. When I started out as a very junior barrister, judicial review was still an ex parte procedure up to permission stage. And although a practice was developing even then in certain quarters, notably in immigration cases, of responding to applications for judicial review and explaining why permission should be refused, there was no formal pre-action process in the way we have now, and there was, to the best of my knowledge, no pre-action disclosure. If permission was granted, evidence was then filed on behalf of the respondent in the form of an affidavit from the relevant civil servant explaining the policy or background to that policy. Ministerial submissions and other internal documents were not routinely disclosed, and indeed there was a lot of resistance to disclosing them. And disclosure, in the sense of disclosure of documents, did not really happen in judicial review proceedings. Before the civil procedure rules of 1998 were brought into force in 2000, courts used to make reference in judicial review proceedings to, quotes, the duty of the respondent to make full and fair disclosure. And see, for example, Huddleston, the citation is on your screen. But that should not be misunderstood as being a reference to disclosure in the modern sense of disclosure of documents. And this is because before 2000, disclosure of documents used to be called discovery. And the effect of judicial review being an ex parte procedure, pre-permission, meant that questions of what explanation should be given in response to any challenge, and therefore the corresponding question of what information or documents should be provided, only arose after permission was granted. Now, over time, there was a gradual change in the disclosure regime, and I'm going to talk very briefly about 3 cases. The first 2 relate to the question of scope, which is my second question, and I'll come back to those. And that's the National Association of Health Store and Secretary of State, which regards the best evidence rule. And the second one is Tweed and Parade's Commission regarding orders for disclosure. But the third case in this trio, and I'm sure there are lots of others, but these are the 3 that I think mark certain points along the way. The third case in the trio is Al-Swady in 2009. This case concerned the hotly contested question of whether members of the British Army killed or ill-treated Iraqis whom they had taken prisoner in 2004. The case was unusual in that there were factual disputes, and the determination of these disputes was crucial in determining which party would ultimately be successful. And the court had held that it was necessary to allow cross-examination of witness statements on hard-edged questions of fact. And an important consequence of the orders for cross-examination was that disclosure was needed, and quite extensive disclosure, to enable effective and proper cross-examination to take place. And this constituted an important exception to the conventional approach in judicial review cases. The duty of disclosure on the Secretary of State in a case such as that was heightened by the fact that the allegations raised concerns of some of the most important and basic rights under the European Convention on Human Rights, namely Articles 2, 3 and 5. And as many people will know, very serious issues concerning disclosure arose. And in essence, what happened was that just before the adjourned hearing, the Treasury Solicitor wrote to the court stating that in light of the discovery of yet further emails and documents, the Secretary of State could not reassure the court that all material documents had been disclosed. And the court held that it couldn't determine the case fairly, and it decided to stay all the claims on that basis. And in the result, there was an excoriating judgment, and enormous costs orders were made. The importance, though, of this case is what happened next. This provoked, so the judgment was handed down, I think, in October in 2009, and there was then some sort of internal review. And as a result, in January 2010, the Treasury Solicitors Department issued guidance. And this guidance is still publicly available, and the link is on your screens. And it's very good guidance in that it tries to set out a clear and coherent scheme explaining the duty of candour and the obligations on central government. But the important passage of this is set out again on your screen, which is that the duty of candour applies as soon as the department is aware that someone is likely to test a decision or action affecting them. It applies to every stage of the proceedings, including letters of response under the pre-action protocol. Now, I would suggest that it's certainly arguable and perhaps more than arguable, that this guidance went further than the case law. And from a public body perspective, one can see how this may be seen as a very demanding obligation. If judicial review is simply an extension of the political process, as it might be said to be in some cases, then one can see why the issue of disclosure is in this review's sights. And if you compare this guidance, which is cited in every well-drafted pre-action protocol letters, which seeking disclosure and then citing or footnoting the guidance in that paragraph, you can see how this can be seen as very burdensome. And you compare it, for example, with the carefully crafted scheme that's contained in the Freedom of Information Act, for example, and indeed there's much longer to answer a Freedom of Information Act request than, of course, the usual 14 days in a pre-action protocol. So it is administratively onerous before a case has even been launched. There can be concerns that the pre-action process, which carries with it this burden, might be a fishing expedition to obtain documents that might not be able to be obtained, for example, under the Freedom of Information Act scheme. And of course, the case at that stage hasn't even crossed the arguability threshold, or hasn't been adjudicated to cross the arguability threshold. So it seems to me that the timing of disclosure obligations may well be something that could properly be the subject to reform, and it might be necessary to build in some sort of safeguards for those cases where some sort of pre-issue disclosure is required. Scope then, historically, as I said before, evidence is given by affidavit. There has been a gradual evolution since the reforms, and the two cases that I mentioned in passing was the National Association of Health Stores, and this was worth just remembering because this was a case in which an explanation of the basis on which permission for a particular, I think it was a homeopathic medicine, had been refused, and there was the normal type of affidavit with an explanation for that given. And Mr. Justice Crane said at the time that he was prepared to accept that if there was a reason to doubt the assertion that a particular factor had been taken into account, the court may exceptionally inquire further into the decision-making process within a department. However, this was effectively exceptional. The appellants who appealed to the Court of Appeal did not appeal that point, but Lord Justice Sedley was concerned about it, and he raised it with the other members of the court. And he said in the main judgment that he raised it with counsel because it seemed to all three of us that we were being required to ignore the best evidence rule by being made to rely on a second-hand account of a document of which the original was available. And he went on to say that it would seem to him to be entirely inconsistent to tender and rely on a secondary account. Instead, the courts would not allow a private litigant to do so, and in a legal system in which the state stands before the court on an equal footing with its citizens, there is no good reason to allow government to do it. In the end, nothing turned on it because both sides were content to proceed on the basis of the affidavit evidence. Nonetheless, Lord Justice Sedley said that the best evidence rule is not simply a handy tool in the litigator's kit. It is a means by which the court tries to ensure that it is working on authentic materials. And he went on to recognise, of course, that an honest witness can make a mistake in the summary that they give. The second case then, and so this was the beginning perhaps or the most significant beginning of a move away from just a witness statement summarising documents, certainly if the best evidence rule made it preferable to just provide the original document. Tweed was then the House of Lords case about the parades in Northern Ireland, and the House of Lords emphasised that the relevant question was whether disclosure appears to be necessary in order to resolve the matter fairly and justly, and said that the disclosure orders specifically could be granted, although they wouldn't normally be required. So in my view, that insofar as a response is concerned, the key points to emphasise are that the starting point is that judicial review is not ordinary litigation, and indeed it's one of the reasons why the ordinary rules about disclosure of documents do not One of the reasons why the ordinary rules about disclosure of documents do not apply to judicial review proceedings is that there is a different and very important duty imposed on public authorities, the duty of candour and cooperation with the court. And that's important because I think sometimes one can start from the starting point that the duty of candour and any disclosure obligations are themselves extremely burdensome, and why should the scope of that duty of candour stay as wide as it is. But I think the answer is that, of course, judicial review is a form, in a sense, of civil litigation, and the obligations that are imposed on parties, and certainly central government and other public bodies, is already an exception to the burdens of civil litigation. And why? And the reason there is that exception is because of the standards that apply to public authorities and central government. And the courts have repeated in many cases, such as relatively recently Citizens UK case, that it is the function of the public authority itself to draw the court's attention to relevant matters. And certainly that case, the quote actually goes on to say that Mr. Beale, approvingly, Mr. Beale, leading counsel of the Secretary of State, put it at the hearing before us to identify the good, the bad and the ugly. And this is because the underlying principle is that public authorities are not engaged in ordinary litigation, trying to defend their own private interests, but rather they are engaged in a common enterprise with the court to fulfil the public interest in upholding the rule of law. So then finally, and taking into account Lord Justice Sedley's reminder about the best evidence rule, you can see how there's an expectation that at least the key documents relevant to the decision will be disclosed. We can all think of cases where the only reason it succeeded is because one had access to the underlying document. And it can be crucial to see what was before the minister. An example of that might be, for example, the Saudi arms case. And indeed, given that one can have a closed material procedure in judicial review, even matters of national security may need, there's a scheme for providing it, albeit to a special advocate rather than a claimant. Is it too onerous? Well, it may depend on the nature of the case. Often submissions to ministers are often quite short, for example, but it may depend. But it's still low, the burden, compared to civil litigation. And finally, it's embarrassing. Internal documents can be embarrassing, and of course it's a human instinct not to want to be embarrassed. And of course, in these days of Twitter and other social media, errors can be magnified in the heat of an issue, and unfairly so. However, we all have to assume responsibility for our actions and failings, and I don't see why a public law decision maker should be in any different position. Thank you very much, and I'm now going to pass on to Alex Goodman to talk about possible amendments to the law of standing.
Hello everyone, I'm going to talk to you about the possible amendments to the law of standing, which have been discussed in the consultation. I'm back in. The consultation documents, I'm not going to speak to slides, I do have some, but just for the shortness of time. The overarching question in the consultation is, does judicial review strike the right balance between enabling citizens to challenge the lawfulness of government action and allowing the executive and local authorities to carry on the business of government? The terms of reference ask whether procedural reforms to judicial review are necessary in general to streamline the process, and in particular whether amendments to the process or the procedure on the law of standing should be contemplated. The panel that's been appointed to look at this has then posed the question, picking up that issue from the terms of reference: do you have experience of litigation where issues of standing have arisen? If so, do you think the rules of public interest standing are treated too leniently by the courts? Now, note carefully the nature of the question here. The question is not posed, should the existing standing rules be broadened, should they be narrowed? It's not posed in any kind of open way. The possibility of existing standing tests are too narrow is not contemplated. The only question is whether standing is being treated too leniently by the courts. Now, that's not because we already have the broadest standing rules possible. And I just asked to consider the rules on standing in the South African Constitution. Section 38 of the Constitution of South Africa is concerned with the enforcement of rights within the Bill of Rights. And that provides that anyone listed in that section can approach a competent court alleging a breach of the Bill of Rights. And it then sets out the persons who may approach a court. And they are, A, anyone acting in their own interest. So that's anyone with traditional concepts of locus standi, person aggrieved, etc. B, anyone acting on behalf of another person who cannot act in their own name. C, anyone acting as a member of or in the interest of a group or class of persons. Anyone acting in the public interest. And E, an association acting in the interests of its members. So in essence, the South Africa Constitution allows pretty much the widest possible form of standing in respect of challenges brought around rights in the Bill of Rights. And those standing provisions have now been replicated in a number of other constitutions around the world, most recently Kenya and now the Gambia. And each of those countries are developing, as a result, more sophisticated jurisprudence on their rights. And South Africa also has very wide standing provisions for environmental claims. So we could be looking at, if we were conducting a kind of constitutional review, the whole question of standing, not just the question of is it treated too leniently by the courts, the question posed by this review. So I think it's important to understand we're not here looking at some sort of Royal Commission or Law Commission type approach. This is a request by the executive essentially for an opinion on which elements of judicial review may be restricted. And that's a great shame for my part, because when one looks at what other countries in the world have done, when South Africa wrote its constitution, it brought together the best constitutional lawyers in the world to discuss over a period of years how to unite a country through its constitutional settlement. And this constitutional review seems rather less ambitious, and I think that's a disappointment and will be reflected in perhaps a less satisfactory settlement overall. So then what are our tests for standing in the UK? We've got broadly speaking, three tests. For judicial review, there is the sufficient interest test. For statutory challenges, including, for example, planning challenges under Section 208A of the Town and Country Planning Act 1990, the question is whether a claimant is a person aggrieved. For claims under the Human Rights Act, the test is whether a person is a victim. So we already have broadly speaking, three different tests that apply across the range of High Court actions challenging executive decisions. The sufficient interest test for judicial review. The classic statement of that is the Crown against the Monopolies and Mergers Commission ex parte Argyll Group test, 1986, under WR 763. And the court there said the first stage test, which is applied at the leave stage, park that for a moment because standing is applicable in our system both at the leave stage and at the stage of granting substantive relief. The first stage test, which is applied on the application for leave, will lead to a refusal if the applicant has no interest whatsoever and is in truth no more than a meddlesome busybody. If, however, the application appears to be otherwise arguable and there is no other discretionary bar, such as dilatoriness on the part of the applicant may expect to get leave to apply, leaving the test of interest or standing to be reapplied as a matter of discretion on the hearing of the substantive application. At the second stage, the strength of the applicant's interest is one of the factors to be weighed in the balance. And so one sees that in many judgments. An important decision is probably Mr. Justice Sedley's view in the ex parte Dixon case. He said there were a number of elements. Threshold at the point of the application for leave is set what he said was at the height necessary to prevent abuse, to prevent those meddlesome busybodies. But he emphasised that to have no interest whatsoever is not the same as having no pecuniary or special personal interest. It's to interfere in something with which one has no legitimate concern at all, in other words, a busybody. But beyond that, the materiality test has no, the standing test has no materiality at the leave stage. And at the substantive hearing then, the strength of the applicant's interest is one of the factors to be weighed in the balance. That's to say that there may well be other factors which properly affect the evaluation of whether the application in the end, and the applicant in the end has a sufficient interest to maintain the challenge. So that's our current judicial review standard. I've mentioned the person aggrieved test and the victim test that apply. Perhaps the executive is looking at some form of amendment which might try to narrow that meddlesome busybody approach by deploying those. One other would be to deploy the assault on the law of standing that was mounted by Richard Drabble QC when he was acting for the interested party on a case of the Crown on the application of key days against South Cambridgeshire in 2003. And Richard Drabble's argument in that case was that the claimant had raised grounds for JR based on a failure of the local authority to have regard to affordable housing requirements, but Mrs. Kiedis had no personal interest in those grounds on which she was relying. In essence, the argument was she just wanted to stop the development on whatever grounds that might succeed. But the Court of Appeal took a wide approach as to whether the claimant could seek to quash the planning permission and rejected that argument. I suppose that's one option. Another might be the person aggrieved test. There's an interesting question whether that is narrower, but it does seem on the balance of authority to be so. Leading authority on that is Walton against Scottish ministers in the Supreme Court. And it's seemingly wide. What Lord Hope said there, paragraphs 152 to 153, in his memorable phrase, he said, "The osprey has no means of taking that step on its own behalf, bringing a claim, any more than any other wild creature. If its interests are to be protected, someone has to be allowed to speak up on its behalf. Individuals who wish to do this on environmental grounds will have to demonstrate that they have a genuine interest in the aspects of the environment they seek to protect and that they have sufficient knowledge of the subject to qualify them to act in the public interest in what is, in essence, a representative capacity. I've never really understood why individuals have to demonstrate those aspects, but that's the person aggrieved type approach, which seems quite broad on its face. But that said, there is a range of authority. The other case of note probably is Ashton against the Secretary of State in the Court of Appeal. And all of these authorities were grappled recently in a decision of Justine Thornton QC, as she was at the time, in a case called Norman against the Secretary of State for Communities and Local Government. She held that Mrs. Norman, who brought the claim, was not a person aggrieved. Now, Mrs. Norman was a local councillor, and she had made the decision to refuse planning permission, which had then pursued to an appeal. It was all about a chicken farm. And she had a particular role in campaigns against chicken farms in Herefordshire. But even though it was her decision that it was at root of the claim, Mrs. Justice Thornton decided she did not have a sufficient interest, or she was not a person aggrieved in the language of the statute. And so that does suggest that there is a narrower approach, because had she, of course, filed a letter of objection at the appeal stage, she would have qualified, but she decided not to, given that she was the decision maker. She thought she shouldn't do that at the appeal stage. So potentially the person aggrieved test is another route for the government. The victim test is certainly narrower. The recent case in the Court of Appeal, Crown on the application of the Israel Burial Society, Lord Justice Singh denied the Burial Society the right to bring a claim against the senior coroner in respect of rules around cemeteries under Article 9 of the European Convention of Human Rights. And so clearly the victim test is much narrower than the standing tests applied in judicial review, where one only has to think of Greenpeace, Friends of the Earth, Liberty, Joint Council for Welfare of Immigrants, etc. all have standing. So there are options for narrowing standing, which is clearly the direction the consultation steers towards. But the difficulty here is what Lord Justice Sedley said in Ex parte Dixon, that the purpose of judicial review is to vindicate the rule of law. It's about wrongs, not about rights. So it's not really about what rights an individual has, it's about the wrongs of public authorities. And our greatest judges have thought that function to be much more important than rules of locus standi. And so the champion of the modern evolution of administrative law, Lord Diplock, said in the Crown against the IRC, ex parte National Federation of the Self-Employed, what's called the Fleet Street Casuals case. He said, "It would, in my view, be a grave lacuna in our system of public law if a pressure group like the Federation, or even a single-spirited taxpayer, were prevented by outdated technical rules of locus standi from bringing the matter to the attention of the court to vindicate the rule of law and get the unlawful conduct stopped." So that's the real concern. The function of judicial review is to vindicate the rule of law, not to vindicate the individual rights of claimants. So it might seem that attempts to legislate away standing or wider standing rules that we have at present might rub up against the judiciary, which is now steeped in the constitutional function of judicial review. However, I wouldn't hold much faith in that. My experience of the judiciary is that they are obedient to the law. There really is no judicial activism, much as the government might think otherwise. If one looks at the way in which Section 31(2)(a) of the Senior Courts Act 1981 has restricted the granting of relief where it's highly likely the same result would occur in an event, I think one can assume that a narrower standing test required of the courts would be obeyed, so long as it did not oust judicial review entirely. That's all I have to say for now, and I'm going to pass over to Kate Olley for the next talk.
Thank you, Alex. I'm going to comment briefly on paragraph 4 of the terms of reference, which I've put on a slide there for ease of reference whilst I'm speaking. I'm going to focus on paragraphs D to G. This is about the machinery of judicial review, and it's the area where the reforms could have the most impact compared to codification of grounds, which might be merely symbolic, which Tim mentioned earlier. So the question is, to what extent procedural reforms might have the effect of channeling judicial review through a tighter and narrower space, and to dovetail with a possible narrowing of the rules of amenability and justiciability. I, for one, would challenge whether there's any need to streamline any further, bearing in mind the impact that's already been brought to bear by the 2015 Act, Criminal Justice and Court Services Act. So first, on time limits, the question is asked whether procedural reforms are necessary to streamline the judicial review process. And the terms of reference ask whether the current procedure strikes the right balance between enabling time for a claimant to lodge a claim and ensuring effective government and good administration without too many delays. Those of us practicing in the planning and environmental field have been dealing for some time with the significantly truncated period of 6 weeks from the date of the decision, with no possibility of a time extension for good reason, as in the case of other judicial reviews. This was acceptable on the basis that it did bring judicial reviews in line with statutory appeals in planning cases in which there was already a 6-week time limit, but of course it leaves very little margin for error. In an ideal world in which the claimant has anticipated the decision and approaches its lawyers fairly instantly afterwards or within a week or two, then bearing in mind to use the pre-action protocol and to offer the defendant ideally a full 2 weeks to respond, then the time breaks down into 2 weeks for initial consideration of the claim and preparation of a pre-action letter, 2 weeks then for the defendant to get back by way of its pre-action response, and then 2 weeks before the last day for filing. And there's no doubt that's sometimes a rush. So it's hard to imagine a shortening of the timetable still further. And in a challenge in the immigration field, the consequences of a tightening of the timetable would be even tougher, given the need in the first place to gather together information such as detention reviews. One important thing which shouldn't be forgotten is, in my view, is the importance of the ability to challenge in the case of an ongoing breach or failure. For example, in the High Court challenge last week to the handling arrangements in place for the eventual decision-making in the Holocaust memorial case in which I'm involved, the challenge rests on the alleged failure to properly transpose an article of the Environmental Impact Assessment Directive when enacting the EIA regulations in 2017, in that it allegedly doesn't guarantee the required independence and impartiality when the decision-making body is also the applicant for the development. That's arguably an extremely important point, which would also affect planning decision-making by local authorities up and down the country, and given the date of the regulations in 2017, necessarily required the claimant to argue a continuing breach. That's my thought about that. Principles on which relief is granted. The questions asked are the remedies granted in a successful judicial review too inflexible? Does that have undesirable consequences? Would alternative remedies be beneficial? Should there be more of a role for ADR, and if so, what type? Well, there's already a role for ADR if the parties want, but that's not appropriate to every case, which will often mean simply submitting to judgment. For example, a planning permission once granted can't simply be reviewed or withdrawn. If remedies were tinkered with so that a decision declared unlawful was nonetheless protected from being a nullity, that would be a seismic change in the world of administrative law, the importance of which can't really be overstated. And let's not forget, we already have Section 84 of the 2015 Act, which requires the court to refuse to grant relief if it's highly likely that the outcome would not have been substantially different absent the unlawful conduct established. That already applies to both stages of the process, permission and substantive. How much further could we go without turning the outcome of a successful JR process into the equivalent of an award of nominal damages? Rights of appeal, including for permission. Admittedly, the permission stage can be relatively lengthy given the paper stage and then the right of renewal. unless the claim is declared totally without merit, even with the court being less flexible about accommodating chosen counsel's dates to avoid. But we've all known cases which have needed to get to the Court of Appeal in order to get off the ground, sometimes important ones. Those are relatively few in number, and I would not see any justification for limiting the right of appeal at permission stage. I'd also comment that the use of the totally without merit marker should not be too extensive and should be saved for genuinely frivolous or abusive cases, perhaps along the lines of the former permission test before it evolved into the test of arguability. And it's questionable whether it's appropriate for this to be applied to a professionally advised claim. In itself, it adds to the time and expense involved. And I've had the experience myself where our claim was marked as TWM and then granted permission by Lord Justice Lewison in the Court of Appeal. As for rights of appeal generally, given the points of public importance which are regularly raised, I can't see any justification for limiting those. I don't really understand the proposition of potentially limiting a right of appeal from, say, the High Court to the Court of Appeal or beyond. And then just briefly on costs, the terms of reference ask whether the costs of judicial review are proportionate, or how should proportionality be best achieved, and should standing be a consideration. That's an interesting link to attempt to link standing to costs, given that it's a separate requirement in its own right, and is relevant in public interest claims, as Alex was saying, in which the costs capping regime already applies. Another question is, how are meritorious claims currently treated, and should they be treated differently? That goes back to the difficulty I mentioned earlier. What constitutes an unmeritorious claim is rather subjective. So do we mean totally without merit here? Or does an unmeritorious claim simply mean one which is unsuccessful? In that case, costs would follow the event, unless the cost capping regime was in place or it was an Aarhus claim, in which case the unsuccessful claimant's costs would already be capped. Next, the question is, are the rules regarding costs in judicial reviews too lenient on unsuccessful parties or applied too leniently? Well, to face the cost bill of several £1000s if unsuccessful at the permission stage, plus needing to pay one's own lawyers, I would suggest already strikes the balance at the outer limit of what is reasonable. I would argue that given the codification of the rules for cost capping orders, which mean that a CCO cannot now be granted until after permission is granted, it's particularly harsh for a claimant to have to face two sets of costs at the permission stage, if the whole point of having a permission stage is to have a filter for unmeritorious claims. Then hand in hand with that should go a relatively light costs regime, perhaps a limit of just one set of costs at that stage. Quite apart from that, the change to preclude the award of a CCO until after permission is granted is already a significant incursion, given the inescapable need to front load the claim. And it's hard to imagine a raising of the costs barrier still further without severely restricting access to court to challenge potentially unlawful decisions. Even in an Aarhus claim, in my view, the cost cap of £5,000 is obviously still a lot more than a lot of people can realistically afford to risk. The costs are already such an inhibiting factor that many claimants cannot bear to take the risk in going ahead. Those are my quick thoughts on those paragraphs of the terms of reference. Thank you.
But as the screen says, thank you very much for listening. We will not be going into a question and answer session. We actually don't have any questions about the substance of the talks that have come through on the Q&A section. If there are any questions that people want to ask, can they send them in anyway, and we'll try and produce some sort of answer in writing when we send around the participants. But for now, can I just say thank you very much indeed for listening, and thank you very much to all the people who've contributed to our panelists. Thank you again.